Here to explain the process and implications of this week's oral arguments is UW-Madison professor Howard Schweber. Thanks so much for joining us again this week.
Oh, my pleasure. Thanks for having me.
Okay, so first off, these oral arguments are happening in Dane County courts, but explain the significance of what this could mean for really laying the groundwork for what we may see in a future Supreme Court hearing.
Right. So the case is, as I think all your viewers know, challenging the 1849 anti-abortion statute. There's also a 1986 anti-abortion statute. And the first thing to know is that 1986 statute is less restrictive. It doesn't have a complete ban. It has a 16-week term, I believe. It's as though there were two speed limits on a road. One it said 70 miles an hour and one said 50 miles an hour. The 50 miles an hour one would be enforced. The stricter statute, if all the statutes are upheld, the stricter one applies. So what is at issue in this case is the 1849 statute and whether it will apply. The argument that is taking place in a court in Dane County, a district court right now, this is the trial stage. This is when facts are presented and arguments are presented about the history of the events. There's no question that this will be appealed to the Wisconsin Supreme Court. And at the Wisconsin Supreme Court level, the only discussions will be about questions of law. And the issue will be, what does the Wisconsin Constitution require in the way of abortion rights?
So from a legal aspect, Attorney General Josh Kaul is basically saying you can't enforce a law that is that old and hasn't been enforced in a long time, correct?
That's one of his arguments. It's a principle called desuetude, which says that when something has been left alone for many, many, many decades, it ceases to be effective. There's an interesting parallel here, which is that Congress just invoked an 1873 Comstock Act that was also invoked by the judge in Texas, banning the shipment of abortifacient pills. So there's a lot of these 19th century laws lying around that are being dug up and brought to fore because with the overruling of Dobbs, of course, now it's not the case that they're obviously unconstitutional. And across the board, one argument is there ought to be a principle that says if no one's seen or heard of this law in more than a century, you really shouldn't be able to apply it now. Is
this a pretty rare argument to make, though? Because you mentioned it's kind of a very modern situation we're running into here where these old laws are being drug up.
It's very unusual. I mean, I'll be honest, before this issue this year, I don't think I've ever seen a desuetude argument made before. Certainly not a law with any constitutional significance. The principle applies to things like contracts and leases more often. So if you have a contract that you haven't enforced in decades, it may be too late to try and enforce it. But that's only one of Paul's arguments. The other argument has to do with the Wisconsin Constitution. Now, the Wisconsin Constitution does not contain a clause that parallels the one that was the basis of Roe in the U.S. Constitution. That's the Due Process Clause. Roe versus Wade, the case that in 1973 established a federal constitutional right to abortion, was based on the Due Process Clause of the 14th Amendment, which speaks of liberty and guarantees due process and liberty to everyone within a jurisdiction. There is no parallel to that clause in the Wisconsin Constitution. What there is a clause that basically quotes the Declaration of Independence and talks about inherent rights to things like life, liberty, and the pursuit of happiness. And that will be the argument at the Supreme Court level, assuming the desuetude argument doesn't foreclose it altogether.
What are the possible outcomes here you mentioned in the district court, and how could that affect when or if, I guess, it reaches the Supreme Court?
Sure. Well, there are really multiple possible outcomes. A flat-out win for the pro-life side would be a declaration that the 1849 law is valid, both on the question of desuetude and under the Wisconsin Constitution. A mid-range outcome, it might be to declare the 1849 law invalid because it is too old, but therefore say the 1986 law now applies. An outright win for the pro-choice side would, of course, be a declaration that the Wisconsin Constitution guarantees the right of a woman to choose to have an abortion, and that all existing laws on the books are in violation of that right and therefore need to be reconsidered. Any of those outcomes is possible. Ordinarily, the case would then go through the Court of Appeals and from there to the Wisconsin Supreme Court. It is possible the Wisconsin Supreme Court will grant what is called expedited review. Say this is a case that's really important, that we're really eager to hear, and that for various reasons needs to be heard right away. But even in that situation, we're certainly looking at least at a process of a couple of months, and it could stretch out longer than that. It could stretch out for something closer to a year before the Supreme Court finally rules. My suspicion is that the court will take this one up quickly, though. My suspicion is that this will reach the Wisconsin Supreme Court by the fall or shortly thereafter, partly because they don't necessarily want to be deciding this question in election season.
Yeah, we're certainly still at the beginning stages of this journey, and we're glad you're taking it with us here, Howard Schweber. Thanks so much for the time here.
My pleasure.